Hi, my name is Amanda Pedrette, and I am an attorney at Hyatt McIntyre & Associates. Our firm largely does estate planning, probate administration, as well as long-term elder care planning, for example, Medi-Cal planning. I am married to my husband, Russell Pedrette, and we have two daughters, Sadie and Henley. I actively participate on the board of directors for the Yuba Sutter Farm Bureau. There we advocate for public policy, public relations, and just generally advocate for the local community of agriculturalists. Through estate planning, we enable clients to take control of themselves and their assets for a time when they are no longer able to do that on behalf of themselves. One thing that I like to tell clients is very important that they don't realize is that the threshold for having an estate in a probate is very low. Right now in California, it's set at $166,250. And so if you're a young couple just starting out with a home and a small family, your estate will automatically qualify for probate administration. Probate administration is very lengthy, very burdensome, and very expensive to those who have to do that for you once you have passed. In the past, you've only been able to have $2,000 in assets to become eligible for Medi-Cal. However, that recently changed in July 2022, and now, as an individual, you may own up to $130,000 in assets, or if you're a married couple or in a domestic partnership, you may have up to $195,000 in assets. Medi-Cal categorizes your assets into two different categories. That is exempt assets and non-exempt. Exempt assets are not countable towards your total value that you can have, the $130,000. So for example, an exempt asset is your residence. You may own one residence while on Medi-Cal, and it is exempt from your countable estate. Also, you can have one vehicle. You may also collect an IRA or a work pension, so long as you take a regular payment of that, like an RMD. If the applicant has $130,000 or more in non-exempt assets, then they will not be eligible for Medi-Cal. Non-exempt assets include a second home or a cabin, for example. It could also be a second or third vehicle. In addition to that, if you have savings or other liquid assets that amount to more than $130,000, those could make you ineligible. There are ways to spend that money down to get you to qualify for Medi-Cal though. Some people have concern that their estate will be recoverable by Medi-Cal, and in some instances it might be. However, if you do some estate planning or use some mechanisms like a revocable trust, you can, as of 2017, prevent your estate from being recovered by Medi-Cal. This has a lot to do with probate. If your estate is probatable, then Medi-Cal will be able to recover. If your estate is not probatable, then it will not be subject to recovery. Receiving an inheritance could potentially make someone ineligible for Medi-Cal coverage. However, in some instances, you can plan accordingly and receive that inheritance either directly and not be ineligible, meaning you're not above that $130,000 threshold, or maybe you can direct it somewhere else, for example, like a trust or an irrevocable trust. There are ways to direct assets to other places so that Medi-Cal recovery is not triggered.